Are you afraid of going to court? You're not alone. Many people experience fear and uncertainty walking into a courtroom for the first time. For many of you, you'll never have even been in the courthouse before, let alone for a divorce proceeding. In this video, we'll go over the entire court process, from before you walk into that courtroom, what goes on during the hearing, and how to address what happens at the hearing afterwards. Hopefully, after viewing this video, you'll feel calmer, more in control, and more confident about your hearing. First, it's important to be prepared before you go to any hearing. And one way to do that is to prepare your documents ahead of time. While you'll be in the hearing, yes, you'll be presenting testimony to the judge. You'll be talking about your story and what it is that you're looking for, but you'll also be showing the judge certain relevant documents that help explain your point or are evidence of what you're talking about. You won't want to have prepared these documents last minute. You'll want to have compiled them weeks, if not months in advance. You'll want to send them to your attorney, and you'll want to have reviewed them with your attorney in advance, so you know what's being presented, why it's being presented, and what you yourself have to say about those documents before you're in front of a judge. Secondly, you won't just want to prepare the documents, you'll want to prepare your testimony. You want to make sure that what you're explaining to the judge is clear and concise. The judge can't give you what you want if the judge doesn't know what you want and why it is that you're seeking that relief. So before any hearing, you'll want to have a meeting with your attorney and go over with them the key parts of your testimony, how to explain certain things so that the judge understands what it is that you're looking for. Additionally, your attorney will help prepare for any questions that the opposing counsel or the judge may have for you, so that you're able to walk into the courtroom knowing roughly what it is that you're going to say and to be a little bit more confident in what you're going to say. Lastly, before you walk into the courtroom, you'll want to make sure you have a good idea of the court etiquette. As I previously said, many of you won't have been in a courtroom before, and different courts have different rules about how you're expected to behave. There's a certain dress code. When the judges walk into the courtroom, you'll need to stand up until the bailiff tells you that you can sit down. Many courtrooms have different rules about whether or not you're allowed to bring a cell phone into the courtroom. And if you're not allowed to bring a cell phone, do you have to put it in a specific locker or do you have to leave it in the car? You'll want to talk over all of these things with your attorney ahead of time so that you know what is expected of you when you walk into that courtroom. And you don't have to have any questions about where you're going or what to do in advance. So now that we've talked about what you do before you've stepped foot in that courtroom, your preparation for the hearing, let's talk about what the hearing looks like, because the hearing can be segmented into various different parts. First is the opening statement. During the opening statement, both attorneys will be able to stand up and tell the judge a short and concise version of what it is that you're seeking. In the opening statement, your attorney will talk about the relevant facts that are going to be put before the judge, some explanation of some of the witnesses, and essentially tell the judge what it is that you're looking for. And a very persuasive opening statement will help set the tone for the judge to pay attention to the evidence that you want the judge to pay more attention to, which is why it is incredibly beneficial to have a skillful attorney on your side to be able to present that kind of opening statement. After the opening statements are done, we turn to the presentation of evidence. Now, there's usually two sides, the plaintiff and the defendant. Unlike a criminal case in a divorce, the plaintiff is just whomever filed first. First, the plaintiff will get to present their case. They'll call all of their witnesses, they'll testify, and then they'll present all the documents that have been prepared that they want the judge to review. After the plaintiff has presented their case, it's time for cross-examination. So the other attorney for the defense's side will stand up and ask the plaintiff's witnesses questions. If you're the plaintiff, do not worry. Your attorney will prepare you for these questions in advance so that you're not blindsided. After cross-examination from the opposing party, it's then the defense's turn to present their case. They'll do all the same things that the plaintiff did. They'll have their witnesses give their testimony, they'll present their own documents, and then there will be cross-examination of the defendant's witnesses. After everyone has presented their entire case, cross-examination has occurred, it's time for closing arguments. Both attorneys will stand up. They'll summarize the facts based off of the evidence that was presented and make their legal arguments to the judge about why the relief they're seeking should be granted. During this portion is when you'll hear your attorney talk about the relevant case law and the relevant statutes and use those and the facts that you testified to persuade the judge as to why the relief you're seeking should be granted. Closing arguments are incredibly important, and you want to make sure that you have a skilled attorney at presenting these arguments to best strengthen your case. After the closing argument is presented, sometimes the judge may take a brief recess to decide what their ruling is going to be. But eventually, you will hear what the judge's ruling is in your case. So after you get the ruling, what happens next? Well, that depends on what kind of order you received. Was it a temporary order or was it a final order? In the case of a temporary order, many times in divorce, there are emergency issues that have to be addressed before you can make it to a trial. You can't wait that long. Things such as custody and visitation, spousal support, child support. You can't wait until a trial. And so many times judges will issue temporary orders to see the parties through until that final trial can occur. If you've received a temporary order in your case, it is very important to start documenting how that temporary order is working, or in some instances, not working, and to communicate with your attorney about how things are resolving afterwards. If things aren't working out, or if you think the judge made a bad call, you're able to do a motion to reconsider to ask the judge to change their ruling. The other type of order is a final order. This is what happens at the end of the case. If you've received this final order and you're not happy with the ruling, things didn't go the way that you expected, the judge didn't listen to a piece of evidence that you believed was relevant, you have options that you should talk over with your attorney. And in fact, many of these options have strict deadlines, so you'll want to talk to your attorney right away. The first option is a motion to reconsider. You have the ability to do that for a temporary order. You have the ability to do that for a final order. It's when you're asking the judge to change their ruling based off of a specific piece of evidence, a specific piece of case law that you think the judge might have overlooked, and you're asking them to take it into consideration and to potentially change their ruling based off of it. The second option is if you believe the judge acted in error, they didn't follow a piece of the law, they misinterpreted it, you have the ability to appeal their ruling. And it's very important that you talk about your attorney as soon as possible about an appeal, because if you miss the appeal deadline, you're no longer able to appeal. Knowing there's an upcoming court hearing for you can be daunting, but you're not alone. My name is Julia Steitley, and I'm an attorney at Melone Hatley, PC. We are your partner in divorce and estate planning, and we have specialized attorneys in family law who are experienced in guiding you through this process so that you are able to do it confidently and be calmer in knowing that your family, your finances, and your future are protected. Call us to schedule a consultation today.